Hello, 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 and testing. Testing, testing, testing. Testing, testing, testing. All right. All righty. So, as you've seen the title today, or right now, this episode, we're going to talk about when a police officer makes an arrest without probable cause or absent a criminal offense. Now, most of you probably noticed that whenever I started this, I didn't do a lot of live shows. Now I am going to be doing an abundance of live shows for you guys where I'm going to be talking and going directly into, the episode. So I'm going to try to be on time. Occasionally I'm going to be a couple minutes late or I'm going to be testing things just like I just did. So just bear with me a little bit because we got to just getting the setup because as you see, the walls are bare and it's an echo in here. So just give me a few minutes on that. But like I said, today, when a police officer makes an arrest without probable cause or in the absence of a criminal offense, because we're seeing this more and more happen throughout the United States. And most people are left either without a remedy, because I literally just watched a video of a young man. He was bit by a dog, and the dog was literally just running through the crowd, and he happened to bite this one young man. And what amazed me by it was that when this young man was bit, the police came and got the dog off of him and then yelled at the man that got bit to just keep moving. And I was like, hold on, you just had an assault. And the way it looked or way it appeared, that this young man didn't even bother to get a name. He didn't do anything. It's just a video now. And most of us don't believe we actually have a remedy for things of this nature. But again, not necessarily an arrest, but it was something that caught my attention because that is happening more often than not. These types of things, being arrested without probable cause or a criminal offense, can give rise to civil rights violations. Most people hear the word civil rights and they immediately go into Dr. Martin Luther King and Rosa Parks and things like that. A civil right is a contracted right. Let's understand what I'm saying. It's contracted because it's protected by the United States Constitution as well as the state constitution that the police officers swear to uphold and defend when they sign their oath of office and file it. That then gives it a contractual right. The contract is not yours, it is theirs. So understand the civil right aspect of it because you have inalienable rights that are given to you by God, not man. Now, when these rights are violated under various provisions of the Constitution and federal statutes, especially 42 USC 1983, the primary federal civil rights violations are implicated. Now, these can be something that's done for the unreasonable seizures, because we looked at what was happening in New York and still happening in New York. That the stop and frisk, it literally damn near bankrupt the city or the state of New York until what they started doing was literally passing out money to actually settle these lawsuits. So those that actually didn't have or participate in the lawsuit, they would get a couple $100s here, a couple $100s there. And I actually spoke about this literally years ago when it was happening. And if you accepted any type of monetary benefits from that, you actually cannot sue afterwards. And generally, a lot of these complaints were settled for literally pennies on the dollar. And they're unreasonable seizures. And that's a violation of the Constitution. In this Amendment 4. Arresting someone without probable cause constitutes an unreasonable seizure of their person. Now, if you look at my video of 100 Days of Supreme, I want to say video 96 of 100. It's titled Beck v. Ohio. Arrest made or arrest must be based on objective probable cause. Now, remember, I also spoke about the probable cause context because probable cause only comes from a crime. I'm gonna say that one more time. Probable cause only comes from a crime. And there are three aspects of that. I'm gonna go into that later today. But Dunaway v. New York, 1979 case, detentions without probable cause, even if short, are unconstitutional. Now, what happens when we're going through these? A lot of times we're missing the minimal points, right? And in the context of these minimal points, we're missing the context of the actual application of the 14th Amendment and how it works. Because in some contexts, particularly with state actors, an arrest without cause may also violate substantive due process, especially if it's arbitrary or egregious or shocks the conscience, which is basically when you're grabbing somebody or someone's being grabbed and they're thrown to the pavement and they're looking for a white man and not this 6-foot black man that they have on the ground, which we see often, more often than not. And what happens is when it's conducted, it's so egregious it violates the fundamental fairness guaranteed by due process, because there's this thing police officers must go through, and it's called the totality of circumstances. So when they say they're investigating, the investigation can't be his word and that's it. It has to be both sides and then finding of something. If that's not done, and then they also have a time limit to do that, because they can't just hold someone without cause. Because again, that's what we're talking about. The undue seizure, even if it's short, is unconstitutional. And then you can actually reinforce that under 42 USC 1983. If even with the context of the cherry picking by the district attorneys, malicious prosecution is one of the most common denominators, because again, they're not going after law, they're not going after legal violations, they are going after the poor and disenfranchised. And that's done through malicious prosecution, because they're prosecuting people even though they know that person did not commit a crime. And if an officer fabricates evidence or causes charges to be filed maliciously without probable cause, it may constitute malicious prosecution under 1983. And this is one of those, well, I'm going to write you a ticket just in case, or for failure to ID. Because most of us fail to say simply, due to the advice of counsel, because it doesn't matter who your counsel is, and the Fifth Amendment, I choose not to answer this or any further questions. Forgetting that simple statement then allows for them to go on and probe and then prolong. And the worst thing you could do is say, I don't mind if you bring a dog, or I don't care what you do, or I'd like to see a supervisor, because now they can extend the stop indefinitely because of your request. Because why? They must be amenable to you at all times. And generally they use the amenability to your detriment, because most people don't understand. Say what you got to say and keep them pushing. Now, in going with that, the malicious prosecution, we go with Thompson v. Clark, and it's a 2022 case. A favorable termination or dismissal is sufficient to proceed with a 1983 malicious prosecution claim. So even without a conviction, you can go with a malicious prosecution claim. So a lot of times people don't know that aspect of it. False arrest or false imprisonment, again, 1983. An arrest without probable cause constitutes a false arrest, and a subsequent detention is false imprisonment under federal law. Because again, what we must show is the officer acted under color of law and the arrest lacked probable cause. These are simple things because again, the police, they go to training for 6 weeks, 9 weeks. Here in Texas, 11 months to actually understand and be able to practice law or actually to learn law. Everybody else is going to school for 7 years. So they're not getting the proper education, which again, Jordan B., City of Prince. The whole context of this is understanding there's an avenue in which you can now, let's say, protect. Because a lot of people ask me, with the amount of lawsuits that I've actually filed and won, why is it I did not take money? And the whole context of it is to be left alone. Leave me alone, because I'll make money. I've done that, will do that, and will continue to do that. And even with that being said and done, it's the now if I give my name, if I give you my information, it's because I don't have the time that I want to deal with you at this moment. I don't have time today. So when you run it, you see, this is not the dude I really want to be bothered with, because my father often told me, there's nothing more dangerous than a fool with a purpose. I've actually threatened, I've even spoken about this. It actually wasn't even a threat. I informed a police officer I would move to Louisiana to sue him. That would be the only reason I would move down there. I would literally pick up from where I'm at to move to sue him, because that's the type of fool I am. But now, what happens is most people will start doing something and they don't understand the procedures or even the application of what they're doing. So they'll put together a lot of things and think and wonder why it's not working. And the things that I show you is the actual process, because the process is going to be the same every time in every case. There will be other pieces that'll be moved because again, the chessboard doesn't change. The moves don't change. Each piece moves a certain way to put you in a place of strategic advantage for the most part. And when we're trying to get creative, the creativity in 90% of the cases are not needed. So when we're doing certain things, we have to understand how each piece moves and why you're moving that piece, because every piece must move with purpose. And that's what this is for. And now, the First Amendment retaliation, if applicable. Because a violation of the arrests were made in retaliation for protected speech or activity, such as filming the police or protesting, this can violate the First Amendment. And this goes again with Naives, I guess, Nieves versus Bartlett, and it's a 2019 case. Arrest and retaliation for speech are actionable if no probable cause exists. Now, what most people miss is the fact that the probable cause only comes from a crime. If there's no crime, there can be no probable cause. And if there's an arrest made or even an extended detention, that is an arrest, because detention wasn't handled properly because there's no probable cause to detain, which is now illegal. You can then sue, and I'll show you, even going deeper into that, how to hold the officer accountable in his individual capacity. And in some cases, you'll be able to seize their assets while this whole ordeal is going on. Because a lot of times they're not going to punish the officer for the things that they're doing or have been doing over an extended period of time. So now I'm gonna throw something else out because I don't hear this one as often. Let's put it that way. Deprivation of rights 42 U.S. 1985. If multiple officers or actors conspire to arrest someone without cause, especially to prevent the exercise of rights or based on discriminatory motives, 1985 may apply. I'm going to say that one more time. If multiple officers or actors conspire to arrest someone without cause. Now, I'm gonna bring up an unpopular case, the George Floyd arrest, because a lot of people did not understand the context of it. You had a gentleman who had a personal vendetta with Mr. Floyd. He was there for a just cause, because he was there because there was a call that was made. Now, it went from a $20 bill to he possibly had drugs on it, which there was no counterfeit 20, and he did not have any drugs. Now, the extending of the arrest or the effecting of the arrest was a violation because there was no probable cause for a crime. Now, the failure to intervene is where the other officers got in trouble, because they knew there was no probable cause, yet they did not stop him, and they stopped others because there is a duty to help. I'm gonna say that one. There is a duty to help. That is also law. So they prevented others from helping him, which made their act a failure to intervene. Bird v. Brisk, and that's a 1972 case. And it's an officer who witnesses an unlawful arrest and fails to intervene is also liable for under 1983 and 1985. If an officer stands by when something unlawful is happening, that officer is also affecting that arrest. And that's one of the reasons why. Now, the remedies or legal actions, again, it's a civil rights lawsuit. Generally, you can go under 1983, the primary federal mechanism for suing individual officers or municipalities. Now, just like I spoke a few minutes ago, injunctive relief or declaratory judgment. Less common but possible if ongoing patterns of abuse, just like I just spoke about. If they've done it before, or there's a prior action or multiple prior actions, you can go for injunctive relief. Now, the most common thing that you're going to have to go against is qualified immunity. Officers may assert this, but it does not apply if the rights were violated were clearly established. This is why we go into the context of using certain case law and certain mechanisms, because we know even in these short trainings, they're taught certain things, and even going into the police department policy. And now, again, these are things that I do often, and this is part of putting together a vigorous defense. And in this case, when you're starting to sue, it's putting together a vigorous offense. So that's all I got for right now. Sign up for the masterclass. It's getting ready to start jumping off crazy. And I'm going to start doing, like other one-on-ones where you're going to have members only meetings and member only lives where you can ask questions and we can have our conversation and we can go and do what we do. So give me a couple hours and I'll be back with something new. Talk to you soon. Supreme.